Good evening, folks. My name is Sandro Stephen. I'm from Indian Angel Network. I'm the host for today. For all of those who are not aware of Indian Angel Network, we are one of the largest angel network in Asia and one of the first in India, with about 500 plus investors on board. Indian Angel Network runs on primarily two pillars. One is the network. The network looks at investing in startups, early stage companies, starting from 25 lakhs up to 6 crore. We also have a fund in place. The fund is a 350 crore fund. The fund looks at investing from $1 million to $4 million. We invest across sectors and happy to engage more with any questions that you have. We'll be posting our email address in the chat room. All of you are interested to get in touch, please feel free to call us. Mail us. We'll be happy to kind of take it forward from there. I hope all of you are ready for an exciting session on the knowledge series that we've been doing. This is the fourth session that we're doing, which is starting up with license, registration, and compliances of a company. We have two great speakers with us, Ms. Shruti Sodhi and Jehaan Shroff. Both of them are from Ketan Group. With this, I'll just introduce briefly about Ketan Legal Associates and Shruti's role. Shruti is a partner at Ketan Legal. She has been she has played a significant role in several path-breaking business transformation to the point that some of them have gone global and been recognized. One of them being Bharti IBM Strategy IT outsourcing multi-million-dollar case study, which is well renowned by Harvard Business School now. She's been active with a lot of startups and helped them in all legal aspects. She's also, and Ketan Legal is also one of the associates with Indian Angel Network. Jehaan Shroff is again a legal guy, LLB, LLM, MBA from ISP. He is associate partner at the Ketan Legal Associate based out of Bombay. With this, I'll let Shruti come in and share more and take it up from there.
Thank you, Sandro. Thank you so much for that generous introduction. And as always, it's a privilege, as I say, to be back on the IAN platform and getting an opportunity to create and contribute to the ecosystem that IAN itself is mentoring and fostering over the years that I have known IAN. And I think I can take the liberty of saying I've known IAN perhaps earliest on in their journeys, and it's been a privilege to be associated with Indian Angel Network. Thank you, and just a brief correction before we start. We are Ketan Legal Associates, and therefore, given there is another familiar name that exists out there, and you did mention us to be Ketan Group, I thought we may as well just take the liberty of making that correction. And, you know, just one logistics information that I will have to make at the beginning of the session, Sandro, and everybody out there in the audience. I do need to apologize that I may need to leave the session earlier ahead of its completion, and therefore, you know, it's a bad thing that I will miss out on all the great conversations and interactions that will happen, but it's actually a very good thing for all of you out there, because I will leave it in better and more able hands of Jehaan Shroff, my colleague, who will you know, be taking the session largely, and I will perhaps keep troubling him as we move along till I'm there with my questions, because largely I'll try and ask him questions with the perspective of the audience in mind, which is essentially the startups, and what could perhaps be coming up for them in Jehaan's conversation and speaking. Jehaan's more able in very many ways. He's not only a lawyer, he's also an MBA in finance. So therefore, ask him all the structuring questions and all the you know, finance and tax related aspects that you may want addressed during the course of the session. So yeah, I mean, you know, Jehaan, over to you, and please take it away.
Thank you very much, Shruti. Very generous introduction. Yes, I mean, while I do have a basic understanding of tax, I'm not a practicing tax lawyer. So if we do have any specific tax related questions, then I will request that, we take those offline, and we'll try and get you specific tax advice to the extent possible.
Absolutely, Jehaan. Thanks for correcting me on
Yeah.
that one.
Right. I'll just screen share with the presentation.
And as Jehaan is sharing screen, I know this is part of the ongoing knowledge series of Indian Angel Network. And the IN team has helpfully told us about the sessions that have already happened, and which have addressed some key aspects of beginning your journey. And this session is essentially for us to share with you, as you begin your journey, what are the legal, compliance, regulatory aspects that you must be aware of, and
I think Shruti, I can't hear you. Shruti, can you hear us?
We'll just wait for probably a minute. She should
Yeah.
be back soon.
So I think she may have just had some internet issues.
Yeah. So just to address to the audience, what Shruti was saying, that the key takeaways for today's session would be on how how you look at the legal aspects and compliances while you register a company. What are the key regulations that you need to consider on those lines?
Sure. Right. And what we've actually done, thanks for that, Sandra. I think Shruti has dropped off because she had some network issues. But
back, but you can continue.
Hi, Shruti. Thanks.
Go ahead.
Okay, sure. So what we've basically broken this up into several parts, and six parts. First is the entire startup regime in terms of what is a startup and how does it work, and what are the criteria that one needs to fulfill in order to A, be a startup, and B, what are the relaxations or concessions given by various authorities once you have registered as a startup. The second one is on the business structures. Effectively, that's to do with the choice of entity, and whether we should go in, or one should go in for a company or a limited liability partnership or a simpliciter vanilla partnership firm. I've not gone into the sole proprietorship space because the startup regime in India does not recognize a sole proprietorship for availing benefits as a startup. So we've avoided that. The third one is on the startup initiative, like I spoke, in terms of what are the attractions, what are the criteria, etc., that one needs to follow. The fourth being the licenses and registrations companies need, and entities that have been incorporated need to keep in mind and fulfill. These are with various regulators. They could be with for employment purposes. They may depend on the nature of the business that one has undertaken, etc. The fifth one is on corporate governance in terms of what one needs to do if were one a company. Effectively, there are compliance requirements. Were you to choose to be a company? And the last one is on intellectual property rights. Just going to briefly touch upon that. I understand that both intellectual property rights and the entire startup ecosystem has has had a separate session, and therefore I don't want to delve too much into that because it may just be repetitive. What I would like to, in fact, spend a significant part of my time on is the business structures, the licenses and registrations, and the corporate governance piece. So, if someone feels that that's not what they would like to discuss and there's something else, happy to, hear any thoughts you may have. Maybe we can pick up any questions on the other sections that you may have later as well.
Sure, Jehaan.
Yeah.
Thanks for that. I think we can start with the presentation, and further questions we'll take towards the end of it.
Sure. Thanks, Andrew. Okay, so just as a concept of a startup, essentially, if you can be a startup if you fulfill essentially three criteria. One is that you've basically not been in existence for more than 10 years. If the moment you've been in existence for over 10 years, you can't qualify as a startup. The second criteria is that your turnover cannot exceed 100 crores in any of the financial years. And in any of the financial years will mean for the first 10 years that you've been incorporated. And as a startup, you are working towards innovation, development, and improvement of products or services, and you have a scalable business model with a high potential for employment. These are essentially the three criteria that an entity needs to fulfill in order to be considered as a startup. Separately, one thing to keep in mind here is that you cannot, divest and hive off or basically remove part of an entity and move it into another separate business structure and then therefore claim the benefits of a startup. It has to be a fresh entity and a greenfield project in the true sense of the spirit.
Jehaan,
Yes.
can you just do a full screen, please? There's a request
Is
that
it?
people can't see it properly. That's why. Control L should work, I think.
Is that all right?
Yeah, I think this is fine. I hope audience you can see. Would appreciate if you any one of you can just type on the chat room. Thank you.
Yeah.
1 second. I think there is some issue. Anup, are you there? Can you just check? People can't see the presentation.
Sandra, would it help if you shared the presentation? I'm not sure if there's an issue with my system.
No, I think, we can see. Audience, I believe you can see the presentation now.
I think it's full screen now, Sandro.
Yes.
It's definitely bigger. We can continue, Jehaan.
Yeah. Okay.
Sure. Okay. Thank you. Right.
It's working fine. Yeah. Thanks.
Yeah.
Thanks. Yeah. Yeah.
Okay. So essentially, like I said, in order to qualify for a startup, there are essentially three business structures or entities that one can consider. The first being a company. You could either be a private limited company. The second is a limited liability partnership under the LLP Act, or the third is a conventional partnership firm, which is not a body corporate. While we do have different kinds of companies like private companies, public companies, there are other different kinds of companies like companies limited by guarantee, as well as unlimited liability companies. I'm not getting into the more complex ones because those are not what one typically sees in everyday life, and I'm going to restrict the discussion at least on a private limited company. One thing to keep in mind. Sorry, was someone saying something?
No.
Okay. One thing to keep in mind is a private limited company and an LLP are what we call as artificial persons incorporated under law, which essentially means that they have a separate legal stature, as opposed to a partnership firm which does not have a legal stature. So effectively, anything that the partners do and is what the partnership firm has also done. The law does not distinguish between the partners of a partnership firm and the partnership firm itself. Okay, just to keep that in mind. Yeah.
And likewise for companies, Jehaan?
Yeah, and likewise for companies, effectively, the law segregates between a company and a shareholder. So both of them will have they are considered different under the eyes of law.
Got it.
Right?
Thank you.
Yeah. Moving on, essentially, like we said, this companies can be either private companies or public companies. Private companies need to have a minimum of 2 shareholders and a minimum of 2 directors. Your shareholders can be either individual or body corporates. Body corporates can be either another company, an LLP, or it could be an entity abroad. It could be a trust. It could be a AIF or a fund that's investing through a pooling vehicle. There's a lot of flexibility there in who can be a shareholder in a company. With respect to a public limited company, minimum number of shareholders is 7, and minimum number of directors is 3. Private companies, in essence, are when it is it is family owned entities that are operating. You usually have a private limited company. The essence being that there is less regulatory control over such entities, and there you can modify or tweak your charter documents, which is your memorandum and articles of association, as per your specific requirements. Whereas under a public company, there are certain restrictions on what can and cannot be included in the charter documents. Okay. We've spoken about number of shareholders, number of directors. We said also 2 and 3 for each of these entities. In addition to this, a point to keep in mind is that each company is required to have a resident director. That is someone who has stayed in India for at least 182 days in the previous financial year. Now, if you have incorporated yourself middle of the year, then the 182 days will be considered pro rata. So that's something to keep in mind. The biggest advantage of a private limited company is the fact that it has limited liability. For any shareholder, the total liability can only extend up to the amount he is required to contribute towards payment of the shares. So beyond that, it doesn't matter what happens to the company. You've essentially ring-fenced your liability, and your personal assets cannot be encroached upon were the company to go insolvent.
That can be a key benefit, Jehaan, for the startups and the startup founders out here, because clearly, while they are ready and raring to go and taking risks, but the limited liability aspect of incorporated entity as a private limited company could be of use for them in terms of ring fencing the risks and liability vis-a-vis the company.
Absolutely, and so your personal assets are not under any threat. That's the main advantage. The next point is on the transfer of shares, and maybe I'm getting a little technical here. We've seen maybe some of you startups already have done your first round of investments, your pre-series A or your angel round, and we have this wonderful document known as a shareholders agreement, which nobody likes to read except when they're in trouble. And we'll have these fancy terms like a tag along right and a drag along right and a promoter lock-in and things like that. So I thought, as part of explaining how the features of a company, we'll just briefly touch upon that, so that you have an understanding in terms of what investors are asking for and why they're asking for it. So as I said previously, in a private limited company, you can tweak your articles to say certain things that you want. And one of them is transfer of shares. Under law, a private limited company can restrict its transfer of shares through its charter documents, being its articles of association. This is not allowed in a public limited company, because a public limited company, by its very essence, the shares need to be freely transferable. So any restriction on transfer of shares cannot be incorporated in the articles of a public company. Of course, shareholders can have an inter se arrangement or agreement between themselves, but that is between the shareholders, and the company cannot be a party to it. That is the main point on transfer of shares vis-a-vis these two entities. Now, with respect to tag-along rights and drag-along rights and promoter lock-in. So effectively what happens is, when any investor is looking to invest in a company, while he does look at the business plan and the projections that the company looks at, and he does his DCF and his valuation modeling, one of the key things that an investor looks at, especially at an early stage, is who the promoter is, and that whether such an investor will actually will gel with such a promoter. And therefore, what investors at an early stage require is for a promoter to not be able to sell his shares, which is effectively a promoter lock-in. As an investor, if I were investing in a startup, I know that the startup and the promoter are one and the same. Without the promoter, the startup's going to effectively die. So I want the promoter to be there. I need him to have skin in the game. And only then will I, as an investor, put in money. Because please understand, I'm not the one with the expertise to run the business. Right? I have surplus money lying around that I want to try and invest. I don't have expertise in running your business, whether it's a tech business or a manufacturing business, whatever it may be. And therefore, it is essential that you continue. And that's why I will have a promoter lock-in. The same principle applies for the tag-along and the drag-along rights. Effectively, as an investor, if you as a promoter are essentially exiting the company, and I have a small investment in your company, I don't want to continue in this company without you. And therefore, I will require what we call a tag along right, which basically means that I can piggyback on you when you sell your shares, and also require the buyer of your shares to buy my shares as well. It's nothing but giving me an exit option were you to exit. I also know that I can exit, and that I'm not stuck in a company without the promoter. Similarly, with a drag along right, effectively the promoter will ask for a drag along right, where he is the majority shareholder, to say that if I want to exit, I can force the investor to exit with me so that I can sell 100% of the company. The reason being that the value of 100% of a company is always more than a pro rata share in the company.
So in effect, adding to what Jehaan's saying, in effect, it's about, the structure. This is a common structure that is preferred by investors per se. And these perhaps are the key reasons why they would prefer a structure such as this, because what they're actually betting on is the idea, the innovation in the idea, and the founder and the person per se. So clearly these, the structure works for that reason, to Jehaan's point. And also, the transfer of shares and all the tag along, drag along, and promoter lock-in features that Jehaan was mentioning about clearly are the safeguards that a new investor in a new idea and a new founder would tend to look at to safeguard and ring fence their investments. Sorry, Jehaan, just thought I'd add that to what you said.
No, absolutely. And yes, because it's a limited liability entity, effectively there is a preference for investors to invest in a company because they also know that there are certain regulatory compliances that a company needs to keep, and therefore it's easier to catch any misdemeanor or unscrupulous activities that may occur in a company. um, the last point on a company is that, as we all know, the way to for an investor to make money on his investment while still remaining a shareholder is effectively through dividend. And we all know that companies effectively now have to pay dividend distribution tax, and there's a 10% withholding today. So any any dividend that is paid out by the company to its shareholders is not considered as a pass-through under tax law and effectively will be taxed. And therefore, we consider a company in a structuring of a transaction to have companies as in between entities is not advisable because they are not tax efficient. Right. Moving forward to LLPs. So traditionally what we had before the LLP scene came about in around 2008 is you had only two options as a promoter. You could either have a partnership firm when there was, and assuming you didn't want to have a sole proprietorship, you could either have a partnership firm or you could have a company. Like we said, the company has limited liability and therefore the promoter could ring fence his personal assets. The partnership firm, unfortunately, does not have limited liability. It has unlimited liability, and therefore a partner rather, cannot ring fence his personal assets, and his house and other personal assets would be on the line were the partnership firm to go insolvent. And that is why a need was felt that we need to have something in between where, while there is limited liability, the compliances are also not so tedious and cumbersome so as to make it cost ineffective to have a company. And that was the birth essentially of the LLP entity, or the limited liability partnership, which by its very name is a partnership entity that has limited liability. Just quickly to go through certain points about it, you need to have a minimum of 2 partners in a partnership in an LLP. These partners could either be individuals or they could be body corporates. That's up to you. What is also similar to how we have directors in a company, an LLP has what is known as a designated partner. Now, a designated partner needs to be an individual. So if a company is a partner of a partnership firm, it will need to represent or nominate an individual who will be a designated partner in the partnership firm. And similar to a resident director, one of the designated partners also needs to be resident in India for at least 182 days. We already spoke about the fact that it's limited liability and therefore the ability to ring fence it. How we have the memorandum of association and articles of association of a company. The LLP will have a partnership deed where effectively all the partners which will be signed by all the partners, and the rights and liabilities of each of the partners inter se each other will be recorded in the partnership deed. Another point is that an LLP does not issue shares. What you do have in an LLP is share of profit, and that share of profit will actually come in as mentioned in the partnership deed. An LLP is typically not a preference for investors. Investors do not like to have an LLP, especially when there is foreign investment, because there are restrictions on which sectors an LLP can undertake its business were it to receive foreign investment. Also, what would happen is that every time an investor comes in, the partnership deed would need to be amended, and that would be more cumbersome as opposed to just tweaking the articles of association were it required. Unlike a company, an LLP and a partnership firm are both tax neutral and are pass-through entities. Effectively, there is no tax that is held back at a LLP level, and any money that goes from the LLP to its partners is directly taxed in the hands of the partners. Right? And lastly, like I said, to bridge the gap between companies and partnership firms, the compliance requirements for an LLP are significantly lower than those of a company. Moving on to a partnership firm, this actually came about, at least the current act is in the 1930s, so it's been here for a while. It's a traditional partnership firm where partners get together and run the business. It's there's unlimited liability, like we spoke about. Minimum of 2 partners are required. Again, partners can be individuals or companies. Here, there is no concept of a designated partner. With respect to partnership firms, registration of a partnership firm is not compulsory. However, if you want to get the benefits of a startup, then the DPIIT, which is the Department of Promotion of Trade, effectively requires that the partnership firm be registered. The principles stay the same in terms of the partnership deed, in terms of the fact that no shares are issued. The profit sharing ratio is what determines the profitability between the partners. Again, this will not be a preference of investors. I have not seen a single investor who would invest in a partnership firm because of the unlimited liability issue. No investor is going to put their personal assets on the line, especially when it's not their business. Again, a partnership firm is tax neutral with respect to payment of profits, and even less compliances as compared to a private limited company or an LLP. Effectively, sorry, Shruti.
Yeah, sorry, Jehaan, just to add to this, that while these are the 3 structures available and all 3 are recognized by the DPIIT, depending on the nature and space that you're in, you may be leaning towards one structure or the other, but the minute you look at its expansion and growth and everything else, then perhaps the structure that will get you monies will be the private limited company as such. And just to kind of add into the point of raising monies by whichever form, so investments, and like Jehaan laid out for us the aspects as to what works and what all will work from an investor's perspective. And I had added in that there is ring fencing available, but just to kind of add to that, were you raising monies through loan and that were being a route that you were looking at, then that ring fencing aspect may not apply. Were the lender, essentially a bank or any other financing entity, were to look at giving you that money, and there certain guarantees by the promoters or the founders may be needed. So I just wanted to add that back into what we had discussed about ring fencing. Sorry, Jehaan, go ahead. You're on mute, Jehaan.
Yes, sorry, it suddenly became difficult to unmute myself. Okay, so yes, one thing to keep in mind in a partnership firm is, sorry, 2 things rather, is that the act of every partner is basically considered as an act of all the partners together. So if, let's say, Shruti and I are partners, anything that I do, Shruti's neck is also on the line for it. Just like this presentation. But
You're definitely doing a great job,
thank you.
Jehaan, way better
Thank
than
you.
me. So
No, no. Thank you.
I'm convinced my neck's not on the line.
Thank you, Shruti. But no, on a serious note, so if you were to do, to set up a, partnership firm, then please keep in mind that these will need to be with people who you've had a relationship with, and that they will not actually defraud you, because you could be be held liable. You will be held liable for acts of all the other partners as well. uh, and that comes from the fact that effectively the law does not distinguish between a partnership firm and its partners. As far as the law is concerned, it's one and the same. You are interchangeable, and that's why you have unlimited liability and being liable for the acts of the other partners. So these are essentially the three main structures that in which investments are received. I have not seen investments from professional investors coming into a sole proprietorship. Um, Similar, like a partnership firm, sole proprietorship is unlimited liability. Your neck is on the line for everything you do, and so are all your assets. Like Shruti said, depending on what business you're in, and and when you're looking to raise funds, you may need to consider a company over the other structures. My suggestion is that it is not difficult to convert an LLP into a company and vice versa. It's a fairly straightforward process. So if you don't have a fundraise in your immediate horizon, you may consider an LLP, and as and when your investors are looking to come in and require you to convert into a company, you can simply convert into a private company. Given the unlimited liability and the concern that being held responsible for acts of other partners, I would not recommend a partnership firm unless there are other compelling reasons that you have to use such a structure. Right. Just to move on now. Yeah. So just to quickly talk about the pros and cons of each of these entities with respect to a private company. We said that it's a separate legal entity. It's not considered. It's different from its shareholders. Your shareholders can be individuals or body corporates. It could even be a trust. That's not a problem. You can raise funds through equity and or debt instruments, which can then be converted into equity, either compulsory equity conversions or optional equity conversions. There's lots of flexibility that a company gives you in respect of fundraising. You have your typical equity shares. You can have debentures, which are debt. Your debentures can be compulsory convertible into equity shares after a period of time. You could have optionally convertible debentures. You can have different classes of shares. You can have a Series A class and a Series B class, give different rights, different voting rights, different profit sharing rights to each of these classes of shares. Really, the world is your oyster when it comes to how you want to separate management and ownership and voting in a company just by issue of securities. Of course, all this will need to be considered when you do get in investments from investors. But as long as the company is your own, and if you want to segregate ownership from management and voting, it's simply, this can be done. You can also, apart from having different classes of shares, you can have preference shares as well. Preference shares effectively have preference over equity shares, hence the name, for over two things. One is payment of dividend, and the second is refund of money were the company to be wound up. So as you can see, again, preference shares, sorry, can be either wholly convertible or into equity shares, or partially convertible, or optionally convertible, or compulsory convertible. it's really for you to decide how you want to structure it. Of course, each of these has their advantages and disadvantages, especially from a FEMA perspective when there's FDI, as only certain kinds of securities are permitted. Um, of course, a company, as we all know, FDI is permitted as per FEMA. Um, FDI in companies is more liberal than it is under an LLP, or for that matter, under a partnership firm. And therefore, this is the preferred choice of investment vehicle or entity for professional investors. The cons, I mean, we've spoken about them. The number of shareholders in a private company cannot exceed 200. You cannot invite the public to subscribe to the securities. That said, you can do a subscription through private placement, where you can cherry pick and choose whom you want to make an offer to subscribe to your securities. And the thing to keep in mind here is that you cannot offer securities to more than 200 people in a financial year under the private placement mechanism. Statutory compliances are more stringent compared to LLPs and partnership firms. We spoke about shares not being freely transferable, and this can be agreed contractually between the parties as well as included in the charter documents to ensure that there is no transfer of shares. And the last point we spoke about, such a structure being tax inefficient. Pros and cons of LLPs.
Jehaan, would you want to just briefly cover LLPs and whatever? I'm keen that you tell them about the licenses, etc. as well.
Sure.
That's the piece.
Yeah, I think we've actually covered, the pros and cons of LLPs.
Largely you've spoken through them.
So it's easier to do business, less compliances. You have an LLP agreement that's fairly flexible. Limited FDI is also permitted. The advantage is that an LLP is tax neutral as well, and the compliances are less. In terms of partnership firm, the main advantage is the lack of compliance. The biggest disadvantage is the unlimited liability that we spoke about. I'm going to quickly go through the incorporation piece because I don't want to get into it because it's technical, and there are many service providers who will just get this done for a fee. And I don't think it's something that promoters really need to delve into. But effectively, for you to incorporate a company, you need to have 2 directors. Your directors need to have what is known as a digital signature certificate, or a DSC, which enables them to sign ROC forms online. And each director is required to have a unique director identification number, which is also issued by the Ministry of Corporate Affairs. Once you have your DSC and your DIN in place, you fill up the application form. You'll have to upload your charter documents, your MOA, AOA, and effectively with that, your multiple applications will get filed for your PAN, for your TAN. You will also need a registered office, so you'll need to decide where which will be the official address of the company, and effectively you submit the documents and you get the incorporation is done in typically a week to 10 days. The couple of points I want to highlight to you here is on incorporation, under law, a company does not need to have a minimum capital at the time of incorporation. However, we recommend that you at least keep some capital with respect to running your everyday business for a while, so that you can meet your daily expenses. Also, when you incorporate a company, you will need to inform the authorities and include in your documents what is the authorized capital of the company. And the authorized capital is the maximum capital that the company can raise. Of course, this limit or ceiling can always be enhanced. There is no problem with it. we recommend not to have a very high authorized capital to begin with, because you will have to pay stamp duty on your articles of association and memorandum of association, which will be a percentage of your authorized capital. So for example, in Mumbai, it is 0.2%, if I remember correctly. So just keep that in mind. So, you know, typically couple of lakhs, start with that and see where you head before you again increase the capital. Increasing capital is not a big deal. It's simple board and shareholder resolutions and you're done. For incorporating a LLP, fairly similar process. You need to have your designated partners. Instead of a DIN, they will have what is known as a limited liability partnership identification number. You need your partnership deed, and you fill up the form, and voila, you have your company. Your partnership firm should be incorporated in about a week to 10 days. Fairly straightforward process. Process for partners, for a partnership firm is very simple. Just decide you want to form a firm, open a bank account as a partnership firm, have a deed ready in place, and you're done. If you need to get it registered because of DPIIT, you get it registered, and that's it. It's even simpler. Okay. The next piece is on the startup initiative, and I just want to quickly run through, you know, some of the benefits that an entity has were it to basically register itself with the DPIIT. The first is on the IPR, and the biggest benefit you get there is effectively you get free advice from IPR professionals in terms of how to deal with your IPR, in terms of its registrations, in terms of its protections. So given that, you know, we've seen more startups in the tech space, there will be some trademark or copyright that will need to be protected. This is a huge advantage were you to register with the DPIIT. There are relaxation in public procurement norms. Were you to go for a public tender announced by the government, you don't need to fulfill the criteria of having minimum net worth or minimum profitability. You don't need to even deposit the security deposit for such public tenders. The self-certification under various labor laws, I will get to that in a subsequent slide. Effectively, the compliance requirements don't require you to register with the authorities, but just require you to give a self-certification and upload it on the portal to say that you have complied with various applicable laws. And in fact, you will also not be, you know, there will be no inspection for 3 years unless there is a complaint of a violation made against you. There is easier funding for startup entities through SIDBI, where they will invest through another fund in your entity. So if you're looking at investment, that's another advantage. Exits are faster. You can wind up your company in 90 days as opposed to 180 days. And the other big, the last and the big Yahoo on this is that you get tax exemption for 3 years. The trick is that you have to choose any 3 consecutive years out of the 10-year period. So you need to be careful which years you choose because you want to maximize your tax exemption, right?
And you do want to choose some before the 10 years expire. So you have to actually balance it out and see when those sweet 3 years would come in for you to take them. So if you wait too long, then you don't get all the 3. And if you, if you do it too early, then you don't get the benefit. So it's basically, I'm sure with your financial advisors and everybody in place, that is one key area that you should keep an eye on.
The process of registration, again, fairly simple, not going to get into it in detail. Once you've incorporated, you register at the portal, you submit the documents, your incorporation certificate, your pitch map, your PAN, any IPR details that you have. confirm your tax benefits that are being availed, and effectively just generate the recognition number after once you've registered. It's a fairly straightforward process. Yes, I did say that one of the advantages is the licenses and registration exemptions. Effectively, if you what the DPIIT tells you is that with respect to certain regulations, you don't need to, while you do need to comply with them, you don't need to be registered with the relevant authority. You can just give a submission of a self-declaration. And these are under various statutes, both under labor law as well as environmental laws, such as the Contract Labor Act, your PF, your ESIC, gratuity, migrant workers, water pollution, air pollution. I think it's also environment protection. I think water pollution has come, oh, it's Amendment Act, CES Act. Okay. So water pollution, air pollution, effectively you can, essentially, you don't need to have to register with these authorities, and you can just give a self-declaration for this period that you're a startup for 3 years. Now, once we have grown up a little bit and we have graduated from our diapers and actually are no longer a startup, effectively, there are certain compliances that one needs to keep in mind. We have the Shops and Establishments Act that is compulsory in every state, irrespective of where you are. Some states have a minimum number of employees, some don't. Please keep that in mind. It's imperative that you get this registration done. There could be criminal liability if it's not done. Usually this registration is valid for a year, so please get it renewed annually. Effectively, this to be in compliance with the Shops and Establishments Act, you need to ensure that your HR policies are in accordance with the Shops and Establishments rules for that particular state. In terms of your working hours, in terms of the leave policy, maternity leave, etc. You need your GST registration. Of course, I think that doesn't need any further explanation. Same with your PAN and TAN numbers. You need to register with the PF authorities under the Employee Provident Funds Act, and you need to make PF contributions, on a monthly basis, with the authority. Couple of things to keep in mind here is that what we've actually looked at, your EPIF and your ESIC and your payment of gratuity. Effectively, these non-compliances or under these acts could lead to imprisonment were you a director or an officer of the company. While it's not typical that one gets imprisonment for non-maintenance of registers or minor non-compliances, definitely if you've not submitted dues or deposited money with the authority, that is a big reason for imprisonment. So please keep that in mind. Do not take these legislations lightly. I can assure you every investor will do a due diligence on these aspects specifically before they come in, because they do not want their nominee directors to have any imprisonment. So please be careful about this. Payment of gratuity, it's not applicable unless you are 5 years old. So if you've just started out, no need to worry about it. Gratuity only kicks in after 5 years, after an employee has completed 5 years. So you can get that registration done in your 5th year of incorporation, after incorporation. We have the Sexual Harassment, Prevention of Sexual Harassment of Women at the Workplace Act. You need to basically incorporate a internal committee that has at least one female member, one NGO member, some external member, and have a prevention of sexual harassment policy in place to ensure that it's a gender equal workplace.
This is becoming very critical, just to add to what Jehaan's saying. Except, while it may look like something that you could perhaps look at once you're of a certain size, but we usually would like to encourage everybody to have the policy and the committee in place in a manner that facilitates, a homogeneous thought process around it as you grow in size and as you would grow in size, because this issues around this, if at all, come up, they can have, obviously it's a legal requirement, but they could also have some sensitive reputational harms also that could come by. And given you're at a nascent stage and you're looking at growing and becoming bigger, any you really don't want any aspects of this to kind of come back and niggle in and become pain points. I just wanted to add that to what Jehaan was saying. Thanks, Jehaan.
Yeah, sure. Sorry, I think. Again, I mean, depending on where you are, you may have sector-specific licenses and registrations. If you're a manufacturing entity, you will have, you need to get consents under the Air Pollution Act, the Water Pollution Act, Hazardous Waste Management Act, Factories Act, either the Boilers Act. It really depends on, if you have a chimney, then you need to get consents for chimneys. I mean, the different acts for different things depending on where you are and what you're doing. If you are in a regulated sector like insurance or banking or an NBFC or a housing finance company, you will need sector regulator approvals. There'll be specific sector regulator laws. Like for insurance, you'll have it laws from the IRDA. From banking, you'll have it an NBFC from the RBI, and you have the Housing Finance Corporation as well. That's a regulator. And if you're going to do an export business, then you will need an IEC code, which is your importer-exporter code, which you'll get from the Department of Foreign Trade. Corporate governance. Oh, what promoters love not doing and what all lawyers harass promoters to do. Okay. So, yes, I mean, you need to be corporate compliant with your corporate governance, your filings, your board meetings. You need to have at least 4 board meetings in a year. These board meetings cannot be more than 120 days apart from each other. Each director has to attend at least 1 board meeting in a year. Otherwise, he would automatically have vacated his office. You can do your board meetings through audio-visual means. However, you need to follow the certain requirements under the Act for this. It needs to be recorded. You should be able to see everybody. Each one should be able to, see and hear each other. And effectively, it should be able to be stored. The recording should be stored. You need to maintain minutes of these meetings. You need to have a separate minutes book for this. And, similarly with your general meeting, you need to have at least 1 AGM in a year. The AGM cannot be more than 15 months apart from each other. It needs to be done within 6 months of completion of your audited accounts for the year end. And you have a minimum number of members to attend are 2 if you're a private company. Again, you need to maintain minutes of these books. Please do that. Any resolution that you've adopted at a board meeting, if it requires any form filing with the ROC, for example, if you've amended your articles of association, or if you've passed any special resolution and you need to file forms with the ROC, please do that. You typically have about 30 days after passing the resolution to do that for a nominal fee. Yes, if you delay, you can please do file it even though delayed after the due date, because it's just a small penalty that's there. And please, one thing we've seen with a lot of companies, they do not issue share certificates, duly stamped and signed share certificates. So please issue that as well. I mean, investors are very particular about that, and that's essential. Non-compliance of these things can result in imprisonment, and depending on the nature of the non-compliance, certain other non-compliances have a daily penalty that could range up to $5,000 a day for every day that you've not done something. So please be mindful of that as well. The penalties are quite onerous in that sense. Um, Intellectual property, just going to briefly talk about patents, trademarks, and copyrights. I mean, like I said, if you were to register with the DPIIT, you will actually get IPR consultancy services for free from professionals. Um, Effectively, if you're filing a patent, please go to a patent agent. Ensure that you've basically the application has been properly filed, it's been published, and the examination has happened by the patent authorities, and you get your patent. Similarly, for trademark, you need to do first to a trademark search, see if there is something deceptively similar, and engage with a law firm who typically get you your trademark registration as well. Similarly with copyright, depending on what copyright it is, whether it is source code, software, if it's any literary work or musical work, depending on whatever the business it is that you're doing. Yes, that's about it from me. I'm going to stop sharing now. Sorry. So, any questions?
Thank you, Jehaan. That
Yeah.
was a lovely presentation. There are a lot of questions in the Q&A block also.
Sure.
I'll pick one by one. You can also have a view of it. It's right there in front of you.
Yeah. We'll just go in order.
Yeah.
Can a Section 8 company, I am not aware of this. I will have to check this, whether a Section 8 company can, in fact, set up. I would, I don't see an issue with it, but I will have to get back to you as well. Someone, I'm not sure how this is moving, but someone's asked me, can you give me a short intro to pros and cons of OPC as well? Oh, one-person company. So one-person company, it's really only for an individual individual resident in India. And therefore you will not be able to get any foreign investment in it. And therefore I would not recommend an OPC structure were you to expand. In private limited companies, what could the shareholding percentage of two directors? I don't follow the question. You could have any share. One is the shareholders and the directors in a private limited company need not be the same. There is no share holding percentage between directors. Directors are not required to hold shares in a company. As regards the shareholders, it could be any percentage that the parties agree to. Okay, Ashutosh has asked, can you discuss about the employee pool too? Okay, I'm assuming you mean the ESOP pool. Effectively, there are two ways an ESOP pool works. One is you can either have a trust structure where shares are essentially issued to the trust, and it is the trust that decides to whom the shares have to be issued. The ESOPs are issued to which employees. That is one option. Or the second option is where you don't have a trust structure and you just keep aside a certain portion of the shares that will be issued at a later date to the employees depending on what is agreed as per the ESOP policy. Okay. Someone has asked, Kaushik has asked on GST for LLPs. Like I said at the beginning, I'm not a tax lawyer. If you want, we can engage and I can get you specific tax advice. Vivek has asked, why do we need to pay stamp duty in such percentage of investment about? Like it doesn't have specific amount. Yeah, so what the stamp duty is actually ad valorem, which means it is a percentage of your authorized capital. So the higher the authorized capital you put in your memorandum of association, the higher the stamp duty will be at the time of incorporation and submission with the ROC. Shops and establishments, when is registration mandatory? I have an online venture and 0 employees registered in the office last 3 years. So some depending on which state you are in, this will trigger. Some states require it for the minimum of 5 or 10 employees. Some states have it as no employees. You can't say that you don't have an office because if you have a company, you will have a registered office. So wherever your registered office is, that's where you will trigger the Shops and Establishments Act. Is shops and establishments registration compulsory for startups? Yes, my understanding is that it is. All work is work from home only. Okay, but you'd have a registered office, right? So I think this goes back to the previous question. The moment you have a registered office, you will trigger the provisions of that relevant state's Shops and Establishments Act. Issuance of share certificates, any conditions for all companies of all sizes? You have to issue the share certificates within 60 days of their allotment. From memory, that's what it is. So that's something you need to keep in mind. Whether you're private or public does not matter. Want to know something about to form a trust or foundation to provide ATG certificate to donor or contributor? I think we'll have to get specific tax advice on that. Can we register LLP and private limited company with authorized capital of 10,000? Yes, you can even do it for 10 rupees. No problem, as long as you're able to meet your expenses within that. DPIIT registration, can it be taken up after a feasibility report for the ongoing pilot study for an innovative process? As such, the company is private limited, already established. Yes, you will need to show them your business plan and your future business that's going to happen. So yes, I would recommend that a feasibility study actually be done. Is it necessary for, Soumya asks, is it necessary for startup, which is freelancing platform, to be registered as a private limited company? And what are some of the licensing? So if you're a startup, you need to register either as a private limited company or a LLP or a partnership firm. The choice is yours, but you will not get a startup recognition unless you've been registered as one of those. So what are the licenses and legal aspects? I think we've already covered that. Can anyone start a fully online startup with no partner? Not possible, because that will be a sole proprietorship. Is it necessary to obtain a valuation report at the time of conversion of CCPS into equity for investors? For offshore investors, the ratio of conversion has to be decided upfront and cannot be less than fair market value. For onshore investors, you can decide it. You can do any conversion rate. If it is not fair market value, there will be a tax impact, depending on whether it's higher or lower than fair value. Why do some startups prefer to incorporate their entities in Singapore rather than India? If you're not incorporated in India, then you can't be a startup. So I'm not entirely sure which startup is incorporated in India and registered in Singapore and registered in India. Can LLP borrow or take loans from private investor or other LLP? As long as I don't see a problem with an LLP taking a loan. Do the office is mandatory for startup to register? Do the office is mandatory for the startup to register? It's not mandatory for you to register yourself as a startup. Can I give resident address as registered office? Yes, you can. It's not a problem. The ROC may ask for an NOC. Given that you will have to give proof of who owns that premises. If you own it, not a problem. If you are a tenant, you may need an NOC from your landlord. Is there any verification from authorities? I'm not sure what verification and from what authorities we're talking about. How can I get in touch with you? Need to restructure my venture. Kaushik, I've shared the presentation with IAN. Kanchi, if you can just share it with them. The last slide has our contact details. Happy to get in touch with you.
Absolutely. What we'll do is we'll just leave our coordinates in the chat right now. And once they write to us, we'll be happy to connect them to you.
Sure. Thank you, Kanchi. Does investor invest without registration? I mean, if I'm an individual angel investor, I don't need any registration. It really depends on who the investor is. How can chartered accountant bring value addition in a startup? What all different roles would be available for a CA? That's a good question. I mean, essentially, I see CAs doing a lot of advisory work for the for startups, especially with respect to taxation. So that's where I see the biggest advantage. A lot of startups don't have a CFO. As a CA, you could also, don the hat of a CFO. Yeah. Is employee pool crucial for attracting investors? No, it's not, but investors do ask for that sometimes because effectively they want to ensure that the management is given incentive to have skin in the game. Are founder and co-founder tags legal requirement? No, they are not. Yes, you can use it however you like. Can I register Udyam under MSME as a startup? I'm not entirely sure what the question is and why one as in is the term Udyam. I don't know what Udyam means. Um, uh, and the next question I have is share certificate issuance mandatory even if only 2 shareholders whose shares details are already in AOA, etc. Yes, share certificate issuance is absolutely mandatory. Not only that, the share certificates have to be duly stamped and signed. And stamping cannot be post facto, it has to be done prior to or at the time of issuance of the share certificate. Yep. I think that takes care of it, Kanchi.
Thanks, Jehaan. That was great. You went ahead and in a single breath you answered all the questions.
What
I felt bad. I was like, I wish you were there in front of me. I would have offered you something.
No, thanks. Thank you so much.
I have one question for you, Jehaan, which I think would be also useful for our audience here.
Sure.
So, whenever investments happen, right? So that's when the legal compliances come in and kick in also. There is a big element of vesting period for founders also as the money comes in, right? So if you could share some insight on that, it would be great.
Yeah, so when you say vesting period for founders, effectively that's what we covered, Sandro, in the promoter lock-in, which effectively means, so, as when you structure a promoter lock-in, you you can structure it to say that all shares will be locked in for a period, let's say, for example, of 5 years, or you can say that, for the first year, 100% will be locked in. For the second year, it'll be 80. For the third year, 60, 40, 20, and then, everything gets unlocked. So that's basically a vested lock-in. So depending on how you structure it, it's just terminology.
No, the reason why I brought it up was because in the rhythm of the whole presentation, sometimes people tend to miss out the key elements also. That's the reason.
No, absolutely. I mean, it's a great question. I'm glad you asked it because, it's important for people to understand, the terminology that's used as well. Otherwise, there could be a mismatch of expectation.
Right. I think that was great. I think we've answered all the questions. Fantastic. Thank you, Jehaan, for taking this up for us. A big thank you to Shruti too, and to Ketan Legal Associates for supporting us with all these questions that have been pumped in by the entrepreneurs, budding entrepreneurs that we have here. Dear audience, if you have any questions you want to get connected to the Ketan Legal Associates, please write into us in the chat room. Both Kanchi's and my email ID is there. You can write freely to us. If you're looking to raise investments, please feel free to reach out to us further for that also. Yeah, I think that's good. Audience, we are done with the 4th knowledge series that we have. The next one, which is going to come in, is on 5th, which is the 5th series, 5th knowledge series, which is with the topic team building and scaling through a startup journey. This is going to be on 9th of October. We have Mr. Venkat Raju, who's going to be one of the key speaker for that, who is a veteran in the industry with about 55 plus companies where he's invested himself. Would be great to have you around. Please look up for more details in the chat room here. You can register yourself to get more insights about the whole deal. Jehaan, once again, thank you. Thanks a lot for all the support that you bring in. Definitely, as and when we get requests from entrepreneurs here, we'll definitely pass them on to you.
Sure. Thank you, Sandro. Thank you to the IAN team and to everyone who's attended. It was a pleasure, and I hope you found this enriching. And thank you for your time, everyone.
Thank you, Jehaan.
Thanks.
It was really fruitful and useful for a lot of people.
Thank you very much.
Thank you.